A woman brought a case to a courtroom, claiming that she bought a horse from the defendants and soon discovered that the animal was lame. Because of this, she wanted a refund. However, things became more complicated. Instead of discussing the issue with the sellers first or following a formal return process, she decided to take matters into her own hands. Without notifying them, she brought the horse back and left it on their property. The defendants argued that this act was a trespass, and they filed a counterclaim for the cost of caring for the horse afterward. The judge began questioning the sellers, starting with how many horses they owned. The seller explained that she had 4 horses, including 1 miniature horse. Most of these horses were rescues, animals she had taken in when their previous owners could no longer care for them. She described how she acquired each one. One was purchased from a friend, another was rescued after being found overweight with neglected feet, and another was given to her without payment because the previous owner trusted she would provide proper care. When the judge asked how she obtained the horse she later sold to the plaintiff, the seller explained that she had known the horse since she was a child. The original owner had gone through a divorce and was unable to care for the animal, so she asked the seller to take the horse. The seller did so freely, paying nothing. The judge questioned why, if she had received the horse at no cost and considered it a rescue, she chose to sell it instead of finding it another caring home. The seller responded by saying she participated in rodeo and wanted to invest in another rodeo horse. Since this particular horse was not her main priority anymore, she decided to sell her to recover some of the money spent on feed, vet visits, and farrier care. Turning back to the buyer, the judge confirmed the important dates. The horse was purchased on July 31, 2016, and returned to the seller's property on August 20, 2016. The buyer insisted the sellers knew she was coming, but the judge cut her off, saying the issue was trespassing, not prior knowledge. The buyer claimed she had trouble riding the horse from the start and called a veterinarian on August 19. The judge asked when she first notified the defendants about any problems. The buyer admitted that the first message she sent was nearly 3 weeks after the purchase, right before she decided to return the horse. The judge made it clear, waiting almost 20 days before raising any concerns was unreasonable. Since the buyer had kept the horse for weeks without early communication, she was not entitled to a refund. The judge dismissed her claim, telling her that she would not be getting her money back, regardless of the buyer's belief that an express warranty existed. After rejecting the buyer's request for a refund, the judge shifted her attention toward the defendant's counterclaim. They argued that once the buyer returned the horse without warning, they became responsible for feeding, housing, and caring for the animal again, expenses they believed she should reimburse. The judge reminded both sides that a counterclaim must be supported with clear proof. She asked the defendants to explain exactly what happened on the day the horse mysteriously reappeared on their property. The primary defendant explained that on the morning of August 20th, she went outside and found the horse tied to the fence near the pasture gate. There was no note, no message, and no sign of the buyer. She said she was shocked because the buyer still legally owned the horse. There had been no formal agreement to take the animal back. She went on to explain that her property was several acres and not open to the public. Anyone driving in without permission was trespassing. She said she felt disrespected and inconvenienced because she suddenly had to care for an animal she no longer considered hers. The judge asked whether the buyer had attempted to call or text before dropping off the horse. The defendants replied that they received no communication until after the animal had already been left on their land. Only later did the buyer message them, stating she had returned the horse because it was unrideable. The judge turned back to the buyer and asked why she believed it was acceptable to return the horse without approval. The buyer insisted she had spoken with the defendants previously and believed they understood the situation. But the judge stopped her immediately, repeating that she could not claim what the defendants were thinking unless she had written proof. The buyer attempted to defend herself, saying the vet had confirmed the horse had a problem and that she believed returning it was the right thing to do. But the judge made it clear that personal belief does not override property law. A buyer cannot simply abandon an animal on private property and expect the seller to take responsibility again. After hearing both sides, the judge summarized the situation. The buyer purchased the horse. She kept it for almost 3 weeks. She contacted the sellers only one day before returning it. She returned the animal without permission. The sellers then had to feed and care for the horse again. Since the buyer could not prove she notified the defendants earlier, the judge told her that her actions created exactly the problem she now faced. The judge then evaluated the defendants' expenses. They presented receipts for feed, farrier care due to the horse's hooves being overdue, and some basic veterinary maintenance. The buyer argued that these costs were unnecessary because she believed the horse should never have been returned to them in the first place. The judge disagreed. She stated that once the horse was abandoned on their land without consent, the defendants had no choice but to care for it. Neglecting an animal, even one unexpectedly dropped off, would have been unlawful. Therefore, the expenses were valid. With that, the judge prepared to announce her decision on the counterclaim. The courtroom grew quiet as the judge prepared to announce her view on the counterclaim. She leaned forward slightly, looking directly at the defendants first. She asked them to clearly list every cost they were seeking reimbursement for. They explained that the horse required immediate feed since it had been dropped off without any supplies. The farrier had also been scheduled because the horse's hooves were overdue for trimming, something they had not expected to pay for again. They further added that basic care, fresh water, stall cleaning, hay, and grain had been necessary during the days after the horse was returned. The judge examined the receipts carefully. She noted that the expenses were modest and appeared reasonable for basic horse care. She then turned to the buyer. "Why?" the judge asked. "Should they be responsible for these costs when you left the horse on their property without permission?" The buyer hesitated. She repeated that she believed the horse had been misrepresented and thought the defendants would understand her decision. She argued that she had not intended to cause trouble or harm, but simply wanted to return an animal she could not use. But the judge corrected her sharply. "Intent does not excuse trespass," she said firmly, "and it does not excuse abandoning an animal on private land." The buyer attempted again to shift the focus back to the horse's health condition, insisting that the lameness issue justified her actions. But the judge shook her head. "You had nearly 3 weeks to alert them," the judge repeated. "Instead, you contacted them only one day before returning the horse. And even then, you did not wait for a reply before going onto their land." The buyer grew flustered, trying to explain that she had been overwhelmed, busy, and unsure how to handle the situation. But the judge's expression showed no sympathy for those excuses. The judge then addressed the entire courtroom, summarizing the legal principles at stake. A buyer is responsible for the property they purchase unless a clear return agreement exists. A seller is not obligated to accept a return simply because the buyer changed her mind or discovered a problem later. Trespassing is unlawful regardless of intention. Leaving an animal without permission places responsibility back on the person who caused the abandonment, in this case, the buyer. The judge paused briefly, making sure both sides understood. She then delivered her decision. The buyer's claim for a refund would remain dismissed. She had waited too long to report any problems and had acted on her own without consent. As for the counterclaim, the judge stated she would review the exact amount of the defendant's proven expenses. The defendants stood quietly, hopeful that their efforts in caring for the horse would be recognized. The buyer, meanwhile, looked frustrated but defeated, realizing that the situation was no longer in her control. Before announcing the final amount, the judge delivered one final remark, almost like a lesson. "When you buy an animal, you buy responsibility. And when you act without communication or permission, you create consequences that the law cannot ignore." With that, she prepared to state the exact judgment.